Welcome to the Loud Little Ducky. Kind of got lazy with this one. As far as the thumbnail thing goes, but Owens v. Echard, this is going to be the motion in limine. Gingers wants to try to exclude people, and he brings up Weinstein. Let's jump in. All right, here we have the motion in limine. Sorry, that was my phone. Owens v. Echard, and oral argument is requested. It says, pursuant to Rule 35AA and Rule 65B and Rule 404B of the Rules of Evidence, Petitioner Laura Owens, Ms. Owens, or Petitioner moves for an excluding the testimony of three witnesses, Greg Gillespie, Michael Maraschini, and Mulvey. As explained below, these three witnesses should be precluded from testifying at trial in the case for two different reasons. First, it appears respondent intends to call the witnesses for the sole purpose of establishing they had similar experiences with Owens, i.e., each witness may claim Owens faked a pregnancy while in a relationship with them. Thus, if she did that to them, she must have done the same thing to Echard. Such other wrongs, testimony plainly inadmissible in this case pursuant to Rule 404B of the Arizona Rules of Evidence. Second, each of these witnesses should be precluded from testifying pursuant to Rule 65B1 because Echard has failed to comply with the disclosure requirements of Rule 49A. In short, Echard has provided zero disclosure fairly describing the substance of each witness's expected testimony, leaving Owens and undersigned counsel to guess as to what, if anything, each witness intends to say. For that reason, separate and apart from the issue of Rule 404B, none of these witnesses should be allowed to testify at trial. 1. Discussion. A. Respondent has failed to timely disclose information required by Rule 49I. Taking the easiest issue first, the court should issue an order precluding Mr. Echard from calling Gillespie, Maraschini, Mulvey on the basis that Echard has failed to timely disclose these witnesses as required by Rule 49I. The text of the rule is clear. Each party must disclose the names, addresses, and telephone numbers of any witness whom the disclosing party expects to call at trial, along with a statement fairly describing the substance of each witness's expected testimony. The purpose of this rule is well settled. The disclosure rules are intended to avoid unfair surprise at trial. See Carlton v. Echard. Trial by ambush is a tactic no longer continuanced in Arizona courts. Adequate disclosures should fairly disclose the facts and issues to be litigated, as well as the witnesses and exhibits to be replied on. Jimenez versus Walmart Stores Incorporated, 206 Arizona. Although this is somewhat flexible, standard disclosures, which only outline issues summarily, are per se insufficient to satisfy the rule. See Brian v. Riddle. Fine disclosure statements did not contain sufficient detail to comply with the rules, where it simply stated witnesses would testify about all matters referred to in a deposition or all matters in the complaint of which the witness has knowledge. Here is a disclosure provided by Mr. Echard concerning the substance of anticipated testimony from Messrs. Gillespie, Maraschini, Mulvey failed to offer any insight into what, if anything, each witness will say. Specifically as to Mulvey, the entirety of Echard's disclosure was as follows. The witness is expected to testify about his prior interactions with petitioner, including his personal knowledge about her alleged fabrication pregnancy back in 2014. A single sentence identifying prior interactions with Owens and generally referring to an alleged fabricated pregnancy does nothing to identify the substance of what Mulvey plans to say about those topics. Based on the lack of any substance to this disclosure, it is entirely possible that Mulvey may appear at trial and say that he initially believed Owens faked being pregnant when she was with him, but he later realized his suspicions was groundless, and he is now 100% certain that Owens was pregnant at the time. No, that's not what he's going to say. But I see you try to put your client's input in there. Or he may say the exact opposite. Yeah, that's where my bet is. Who knows? Because Mr. Echard has failed to disclose anything in the terms of substance of Maroney's testimony. Owens has no idea what to actually expect. Maybe these guys are going to tell the truth, and it's to show a pattern. Will it be cumulative? I don't know. It might be. The same problem exists with respect to both Maraschini and Gillespie. Contrary to the mandatory duties imposed by Rule 49, Mr. Echard has disclosed literally nothing about the substance of what either of these witnesses intend to say, given the trial is barely 40 days away. Mr. Echard's failure to comply with this disclosure obligation is inherently prejudicial and inexcusable, meaning the only appropriate remedy is exclusion. See Zern by through Zern v. Ford Motor Company, which was in 1996. Affirming exclusion of late disclosure information on the basis untimely disclosure occurred less than 60 days before trial. See Family Law Rule 65B 1B. Where party fails to timely disclose information, the court may issue order prohibiting the disobedient party from supporting or opposing designated arguments or from introducing designated matters in evidence. Because Mr. Echard has failed to timely disclose information about the substance of the witnesses' testimony, he should be precluded from calling them at trial. B. Evidence of other wrongdoings is inadmissible. Now, this is where I talk about it can be cumulative. And I get his point. Just because she did it with those three guys doesn't mean she's doing it here. Or just because she did it with Clayton, it doesn't mean that she faked a pregnancy with the other three. And so I get what he is saying. It can become too much. And I mean, I think the judge can just look at it in filings. I don't know that it needs to be fully addressed at trial. Because again, they're only given 2 hours. So to have expert witnesses, but that's the problem, is this, a 2-hour thing should solve all this. But because there's so much lying and falsifying, it's really hard to do in 2 hours. I think the judge probably gets the point. And I don't know if she'll actually say, other than giving a judgment, I don't know that she'll actually say anything to her with her ruling, but it'll be interesting to see. Mr. Echard has made public statements claiming he believes Owens faked pregnancies with one or more prior boyfriends, including the 3 individuals listed. As noted above, Mr. Echard has not formally disclosed anything about the substance of each witness' expected testimony beyond extreme general suggestion. Each witness will say something about past experience with Owens involving an alleged fake pregnancy. This type of wrongdoings evidence is inadmissible under Rule 404B of the Arizona Rules of Evidence. That rule provides, except as provided in Rule 404C, evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show action in conformity therewithin. Now, it's not supposed to go to character, technically, but it can go to credibility. And that's where 404 stuff can slide through. Rule 404B is simple. It provides when a person is accused of a specific act of wrongdoing in case number 1, it is improper to prove guilt or civil liability by offering evidence the person did something similar in case 2, 3, or 4. See Elia v. Pfeiffer in 1998. Concluding under 404B, character evidence of other wrongdoings is barred because it is slight probative value and because admission of such evidence gives rise to a strong likelihood of prejudice. Such evidence substantially permits the trier of fact to reward the good man and to punish the bad man because of their respective characters, despite what the evidence in the case shows actually happened. Evidence one child was given a hard spanking by a mother, inadmissible under Rule 404B to prove mother injured different child on a different occasion. Which I get. I get where he's coming from with this. I do. But is any of this going to matter because of the fact that it's judge and not jury? Because the judge can, weigh prejudiced and probative and things like that, and she knows that you can't punish somebody based on this, but it can go to her credibility. And some of these witnesses may have proof that she lied. The problem also is that she has not been convicted or found liable or to be lying in any of these other cases. But if she is to be here, it can be brought up in another case, because she's been found to have done something. Alright, so evidence showing party broke the law in past is explicitly prohibited to show the same party broke the law later, on a later occasion. So we get all those. One of the clearest and most analogous examples of how Rule 404B applies in the situation occurred literally days ago, when the highest court in the state of New York, here we go, to Weinstein. Let's keep bringing up these despicable characters into your client's things. Weinstein and whatever your opinions are of Trump. Why do you need to bring them up? The most controversial people out there, you have to put them in your filings. But I get what he's coming from, because that Weinstein overruling actually proves, is showing what he's trying to get across. The Court of Appeals reversed the R conviction in the infamous movie producer Harvey Weinstein. In that case, Weinstein was convicted of SA and rape as 3 specific victims identified as victims A, B, and C. But at trial, the prosecution allowed 3 other women to testify that Weinstein had also R'd them. The Court of Appeals explained this testimony violated New York common law rule, which is functionally identical to Arizona Rules 404B. The general rule is against receiving evidence of another offense. A person cannot be convicted of one offense upon proof they committed another. People v. Weinstein, 2024, New York, Lexus, whatever. Okay, the court explained the rule exists to ensure fairness. I think part of the problem there, Emily D. Baker did a good breakdown of why this got overturned, and breaking it down and why it would be good. Certain things could happen this way when he gets a new trial, because it'll be different because he was not convicted yet of those other victims, but he will be as of now, so it'll be different. So that's what I was explaining. Owens doesn't have something that says that she's done this before in in the eyes of criminally or even in civil. Nothing showing that she has done it and it's in black and white. But we know she has proof. It's just now coming to light and everything is unfolding now. So that might change for Owens herself. I will link Emily D. Baker's video on explaining the Weinstein overturn. If you want to watch it, it'll be in the description box if you haven't already seen it. Testimonies from 3 individuals about their own unwanted sexual encounters with defendant were therefore unnecessary. Indeed, the testimony served to persuade the jury that if he had attempted to coerce those 3 witnesses into non-consensual sex, that he did the same to the victims on the dates and under the circumstances as charged. That is pure propensity evidence, and it is inadmissible. Over a century later, we reaffirm that no person accused of illegality may be judged on proof of uncharged crimes that serve only to establish the accused propensity of criminal behavior. So there you have it. Those crimes at the time when these victims came in were uncharged, unconvicted. They were not convicted at the time. Since he has had the LA conviction of these LA victims A, B, and C, there is proof of charged crimes and convictions on those crimes. They're not just coming in to say, yeah, me too. Because it's been proven and he's been found guilty to have actually done those things. So now they can say, well, he is guilty of doing these other ones, to show that and it's not to say that he did it with them, so he did it with these. It's to show probably his credibility, and that he has been known to do it. It can be a pattern, and you have the right to show those patterns and show things that have happened. That's also why in the Murdaugh trial, some of his stuff could come in. Now, should everything have come in? No. But the ones that he had owned up to and he had already been found guilty of, or he pled guilty to, those can come in because those are already charged and he was already sentenced on those. So those can come in. Now, the other stuff that he wasn't fully convicted of or hadn't pled guilty on, those maybe shouldn't have come in because they were cumulative, and it is just going to show, because he did it here, he did this stuff, he's bad, he does all this stuff, that means he did this. Which I'm sure that all of you understand what I'm saying. I'm sure you understand what he is saying. And we need to at least acknowledge that this can be viewed as that. We can't just say, oh, everything he says and does is stupid and dumb. This could very much so be the thing, given that there's also only 2 hours. So I want to point out when there are valid arguments and when there is not. All right, so moving on. Of course, Mr. Echard will surely note evidence of other acts may be admitted for some other purpose, such as establishing motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. But in the unique context of this case, none of those exceptions apply. I don't know why my daughter is in a yelly mood today, but she is. She's very loud. Evidence showing Owens made a false allegation of pregnancy in the past does nothing to demonstrate her motive, opportunity, intent, preparation, plan in this case. This is so because the alleged motive/plan here is entirely self-explanatory. Echard believes Owens faked being pregnant as a way of trapping him and or to force him into continuing a relationship with her. This theory is obvious on its face without the need of support from witnesses. Yeah, but it's good to have other people have your back and witnesses. It's always good. It is essentially purely rhetorical argument that could be made in any similar situation, including in cases where the pregnancy results in the birth of a healthy child. Men who find themselves in Echard's position have always accused women in Owens' position of lying about being pregnant as a way to gain leverage. But that's not what's going on here. It's not what's happening. But okay. Like the other ones that are doing it, maybe they've done an April Fool's joke saying, oh, I'm pregnant, which never do that April Fool's joke. It is so, what is the word for it? Unsympathetic. It's just not right. You shouldn't do it. It's lying about pregnancy, cancer, and being sexually assaulted and things like that. Those are like the top 3 things don't joke about. Don't do an April Fool's joke or anything on it. But my point is the ones that have said that, are they saying they are lying because maybe the person that's saying they're pregnant has done something like that in the past? They have lied to them about pregnancy previously. And then there's the men that they're not men. They're little boys who don't want to own up and take responsibility for a child that they have caused. I do not think that that is Echard in this situation. It's also another thing about which he's going to point out about fatal attraction. There are men or women who have affairs, and the woman, the mistress or something, ends up pregnant. And now the mistress wants to go tell the wife. And the husband wants to say, that's not my child, she's lying, she's just a hoochie, and so forth. So, yeah, but that's not the situation we have going on here. Whether or not Gingras wants to own that fact or not, he knows that's not what's going on. Clayton has no leverage to be gained here, other than the fact that it proves that he is telling the truth. And he's not lied about anything. That same classic theme forms the plot lines of countless films, including the 1987 thriller Fatal Attraction, or as Megan Fox likes to say, Fetal Attraction for this case, in which Michael Douglas has an extramarital affair with Glenn Close, who later claims she is pregnant before she repeatedly stalks Douglas, kills his family pet, Bunny, by boiling it in a pot, and famously warns, I'm not gonna be ignored, Dan. Sadly, that, aside from the killing the bunny pet thing, sounds a lot like Owens. Maraschini, you're not gonna ignore me. You're not gonna break up with me. Because if you do, I'm gonna claim this. You need to stay with me, or I'm gonna unalive myself. Clayton, if you don't do this, and you ignore me, I'm going to the media. I'm gonna take you to court. Same with Gillespie, and probably same for the 2014 guy. And I'm sorry I'm not always gonna say his name. I didn't even want to say it in this filing, because I want to respect the fact that he doesn't want to be out here. But that sounds exactly like Owens. And then he puts in his footnote the Fatal Attraction clip, which I will link in the description box. Not playing it here because I don't want to be copyright struck. If you want to go watch that clip, I'm going to actually go and watch that movie because I've only seen pieces of it. I haven't watched it all the way through. If Mr. Echard believes Owens wanted to trap him, he does not need to call any other backup witnesses. He can offer the argument based entirely on his own personal knowledge and belief, and the court can either accept it or reject it. Okay, so is that how we do murder cases? Don't put on any witnesses to back up your theory that you didn't kill somebody. The judge can either accept or reject the fact that you did or you didn't. Don't have anybody come up here and explain things. Like, what sense does that make? None. Zero. That one's a dumb argument. Of course, it is undisputed this plan did not work in this case, assuming a plan even existed, which Owens completely denies, which we don't care what she says because she's a known liar. After their one night together, Mr. Echard flatly refused to have any further romantic relationship with Owens. If Owens' intent was to trap Echard, the plan was a complete and total failure in every respect. Nobody said the plan had to be successful in order for it to have happened. Her writing up a dating contract stating that she's pregnant, but she will get rid of them if he dates her, that's a plan. Clayton didn't sign the contract because he's smarter than that. And so, yeah, her plan failed. Doesn't mean that it didn't happen. In and of itself, this would strongly negate any suggestion Miss Owens falsely claimed to be pregnant as part of a sinister plan. No, it doesn't. Just because Clayton didn't agree and fall for her plan doesn't mean that she didn't have a sinister plan. How do criminals get caught all the time? Because their sinister plans didn't work. They were a total failure in every respect. Thus, even if Owens did somehow fake being pregnant in past prior cases, which she denies, that fact would have absolutely no bearing on the issue whether she was actually pregnant in this case, a point in which is supported by objective medical proof. No, it is not. And I hope that the judge, as a female, probably as a mother, and as a wife, maybe as an aunt, a granddaughter, something, tells them what objective medical proof is for pregnancy, because this ain't it. These contested stories about past relationships do nothing, at least nothing meaningful, to support the idea that Owens falsely claimed to be pregnant in order to trick or trap Echard into dating her. She put Mr. Owens. Trick or trap Mr. Owens. No, in her dreams. Instead, Mr. Echard's intent here is obvious. He wants to offer testimony from one or more of Owens' past ex-boyfriends to show she lied about being pregnant with them, therefore she probably lied about being pregnant with me. Here's where I kind of disagree with his point, where I got his argument. I think it's a good argument, and you have to make this argument because you're zealously advocating for your client. I agree he needed to make this argument and have it. The thing is, I don't think that Woodnick and Clayton are offering up these 3 exes to prove that she lied in those cases, she probably lied in this one. They're using them to prove this is a pattern, that she is a serial pregnant fraudster. That these things happened in their case, they also happened in my case. Not to say, see, she did it here, that means she did it here. No, it's to see this proof, and this proof, are all similar, or things that were used in this case were also used in this case, like, because some of the stuff overlaps. So that's where I don't think they're saying, oh, she did it with them, she did it with me. I think it shows their pattern, which they want to show, that she does this and they want her to stop. And it may not be able to be used in this case. Gingras and Owens may win on this one. And hopefully now these guys can go back, because of everything that's been uncovered here. In this case, as I have labeled my playlist, Bachelor uncovers the truth of Laura Owens, that they can go back and get justice against her. And maybe the courts can apologize because they didn't have the information. And the guys didn't maybe have attorneys or know what they were dealing with. And since she possibly will have been found to have done this to Clayton, they can go back. Maraschini now has more than he had back when his case was, like in 2018. He has more now than he in 2024 than he did then. So he can go back and sue her. Whether it's for his name or for financials or whatever, he may decide not to. This may be good enough that his name is cleared in the public. But if he wants that in court and to get these stupid protection orders that Owens does not deserve or need off their record, and it was done by lying and falsifying information. All right, let's move to the conclusion. Court explained in Weinstein that it is pure propensity evidence and it is inadmissible. The same is true here. Conclusion: for all the reasons stated above, petitioner moves the court for an order precluding Echard from calling Gillespie, Maraschini, Mulvey as trial witnesses, signed by Gingras on April 30th, 2024. Here's the good faith consult certificate. That good faith attempt to resolve the issues in this motion by consulting with opposing counsel, but those efforts were not successful. So that is the end of the motion in limine. Quote of the day: don't play the victim to circumstances you created. You created all the prior bad acts. You falsified all the documents. You lied to your exes. And now you want to act like you're the one that is hurt. What you have done to these men is ridiculous. It is criminal. And in these circumstances, you are not the victim. These men are the victim. And this is not the believe me, I'm a little old woman time. We don't play that game. You're the girl who cried wolf too many times, and it has caught up with you. Own up to what you've created and move forward. That's the only way to get better. But do not play the victim, because you caused this mess. I will see you in my next video. That's where we end it. Like, subscribe. I was on a different computer editing this video and putting it together, so my thumbnail stuff isn't the best today. please forgive me. I will do better going forward. And I will see you next time. Bye.